of Pamatong versus Comelec with the General Register number 16-1872 on April 30, 2004. The petitioner here is Eddie Pamatong and the defendant is the Comelec. Facts, Pamatong filed his certificate of candidacy for president. The Comelec refused to give the petition its due course. Pamatong requested the case for reconsideration. The Comelec again denied his request. The issue here is whether or not the Comelec's refusal to Pamatong's request for presidential candidacy violated the right to equal access to opportunities for public services. And the ruling here is no. The court noted that the provision under Article 2 is generally considered not self-executing.
Good morning everyone, I am Glenn Serena. My first case is all about Araneta versus Ingasal, case GR number 2044. The promulgation date is August 26, 1949. Fact, the view of the state of World War II in 1941 Commonwealth Act CA 671 was adopted by the National Assembly. It authorizes the President to promulgate rules and regulations with such authority. CA 671 did not expressly fix the term of its effectiveness, so several executive orders by the authorities vested with CA 671 are issued. Whether CA 671 ceased to have force and effect. Ruling is yes, emergency power is temporary or it can extend to the any emergency. It is clear that the language of Section 3 of CA 671 that the legislative body did not intend to limit the duration of the action. The emergency power EOS issued after the adjournment of the regular session of the Congress in 1946 are valid, but EOS issued after the date are not.
Good morning, I'm Pamela Concepcion C. Daria. My first case titled Grace Poe versus Comelec. GR number 221697 dated March 8, 2016. Facts about the case. Grace Poe is a natural-born Filipino citizen, declared her residency before the 2016 election as 10 years and 11 months. She was legally adopted by Ronald Alan Kelly Poe, or also known as FPJ, and Jesus Sonora Poe, or also known as Susan Roses. She immigrated in the U.S. in 1991, and by 2006, she reacquired her Philippine citizenship. By 2010, she renounced her American citizenship to satisfy the RA 922 health requirements. The petition were filed before the Comelec denied her candidacy. Issue: whether or not Grace Poe is a natural-born Filipino citizen. Ruling: yes. Grace Poe is a natural-born Filipino citizen, meets the constitutional requirements for running for the presidency due to her physical features and her birthplace in Haro, Iloilo, supporting the 99% of her Filipino parents. Admissible under Rule 128, Section 4 of Rules of the Evidence.
Good morning everyone, I am Arshini Julia and my case study is General Register number 16187. Pamatong versus Comelec, April 13, 2004. Related provision is Article 2, Section 26 of the present Constitution, equal access to public service. Facts of the case. The petitioner Pamatong filed his certificate of candidacy for president. Pamatong is one of the 35 other candidates who was identified as a nuisance candidate of the Comelec. It because they could not reach a national campaign or not nominated by a political party or not supported by a registered political party. Comelec based its decision in the Omnibus Resolution number 6604. In this case, Pamatong was contending that limiting the numbers of candidates and allow those who can afford a national campaign or those who nominated by a political party, while the Comelec is amending the Constitution, particularly Section 26 of Article 2. Issues related to the provision is that whether or not Pamatong had invoked his right under Section 26 of Article 2 to equal access to public service. Loading of the Supreme Court. The Supreme Court remanded the petition and ordered the Comelec to submit the evidence that proved that Pamatong is a nuisance candidates. Section 26 of Article 2 is not a self-disclosure. There is no judicially constitutional right under this provision. Supreme Court also pointed out that equal access, public service, and are subject to multiple interpretation, but they may be subject to multiple interpretation. Also, Commerce commented that limiting the numbers of candidates are to avoid mockery and nuisance candidates and allow those who can afford a national campaign or those who nominated by a political party. The decision of Supreme Court is to dismiss the petition and that 88 Tomato was eventually declared as innocent candidate and was
Espanola. I'm going to tackle about Basco versus Falcor. Year number 91649, May 14, 1981. Petitioners are Basco and associates, while the defendants are Aguirre, Laborte, and Capule. Facts. Petitioners are seeking to annul the patent because it is allegedly contracting to morals, public policy, and order, and because it constitutes a waiver of a right prejudicial to a third person with the right recognized by law. It waived the Manila City government's right to impose local taxes and license fees, which is recognized by law. For the same reason, the laws intruded into the local government's right to impose taxes and license fees. This is in contravention of the constitutionally enshrined principle of the local economy. Issue: whether or not it waived the Manila City government's right to impose local taxes and license fees, which is recognized by law. Ruling: no. The fact that Pagor is exempted from paying any kind of tax is not violative of the principle of the local autonomy. LGUs have no inherent right to impose local taxes and licenses.
My name is Maria Jovali Punagua and my case title is Carmen Crostel versus Indias Fernando, year L 5156, March 11, 1954. Facts. Carmen Crostel filed a suit against Elias Fernando, the director of the Bureau of the Public Works, for taking possession of the 3 parcels that the land that she owns and causing an irrigation canal to be constructed there without obtaining first the right of way and without her consent and knowledge and against the express objection. Carmen Crostel demanded the return of the land and its restoration to its former condition. Issue: whether or not Elias Fernando is immune from suit for being a public officer. Ruling: no, Elias Fernando is not immune from suit for being a public officer because according to Article 32, Civil Code, Article 32, the Civil Code provides that any public officer or employees or private individuals who directly or indirectly obstruct, defeats, or violates, or in any manner impedes or impair any of the following rights or liberties of the other person shall be liable to the latter for the damage.
Good morning, ladies and gentlemen. I'm Jonna Rose Dikusay, and today I'm gonna discuss a 3-case digest. So my first one is CA number 671 or 671 with the title Araneta versus Tinglasan. So the parties involved here are Araneta as the petitioner and Tinglasan as the respondent. Facts of the case: the petitions challenge the validity of executive orders issued under CA number 671, which declared a state of emergency due to war and authorized the president to promulgate rules. 5 cases, including those against Antonio Araneta, of being charged for violating EO 62, which regulates rentals for houses and lots for residential buildings. Another case is of Leon Guerrero, seeking to have permit issued for the exportation of his manufactured shoes. Another is of Eulogio Rodriguez, seeking to prohibit the treasury funds for disbursement. And Antonio Barredo attacking EO 226, which appropriated funds to hold the national elections. They contend that CA number 671 or Emergency Powers Act is inoperative and all EOs issued under it have ceased. The issue here is whether or not the executive orders issued by the President pursuant to CA number 671 or Emergency Powers Act have ceased to have any effect, notwithstanding the fact that the text of CA number 671 has an expiration date as per its effectivity. Ruling. The court ruled that a rule should be tested based on its results, including the law's nature, object, purpose, and relation to the Constitution. The Supreme Court ruled that a separate law repeal is unnecessary due to Article 6 of the Constitution, which mandates temporary laws for national policies during war or emergencies.
Hi, good morning everyone. My name is Justin Marcobispo, BSB 81 from City University of Pasay. The title of this case is Elements of State, Sovereignty, Defense of State. GR number 145892. The facts. In 1936, Tranquilino Lagman has reached the age of 20 years old, and he was being compelled by the Section 60 of Commonwealth Act 1, or also known as the National Defense Law, to join the military service. But Tranquilino Lagman refused to do so because of one, he has a father to support, and number two, he has no any military leanings. And number three, he does not wish to kill or be killed. Lagman further assailed the constitutionality of this said law. Issue: whether or not the National Defense Law is constitutional. Held: the duty of the government to defend and protect the state cannot be performed except through an army. And in fulfillment of this duty, all citizens may be required by law to render civil service. So yes, the National Defense Law is constitutional. Thank you.
Good day everyone, my name is Rachel Castor and my first case is GR 170603, Edison Saw versus Republic of the Philippines, dated January 29, 2007. Facts. Edison Saw filed a petition for naturalization under Commonwealth Act 473. In the proceeding, he contends that he was born in the Philippines, a man with good character, and had been studying in the UST, where she was graduated as a cum laude in pharmacy and was then taking medicine. He also presented two witnesses, attorney Artemio Jr. and Mark Salcedo. Issue: whether or not the person presented are credible as witness of Edison Saw naturalization process. Ruling: no. According to the court, the citizenship is the highest privilege that the Republic of the Philippines can confer upon an alien. It is a privilege that should not confer except upon a person who is fully qualified for it. Another issue that was pointed out was the fact that the petitioner was only 20 years old at the time of the petition, where it was physically required that the person who is filing for naturalization should not be less than 21 years old to such date.
Good day everyone, my name is Jasmine Geronimo and the topic of my first case is about Marcos versus Comelec, GR number 119976, dated September 18, 1995. So facts. Petitioner Imelda Romualdez Marcos filed her certificate of candidacy for the position of the 1st District of Leyte in 1995, providing that the residence in the place was 7 months. On March 23, 1995, Cirilo Roy Montejo, the incumbent representative of the 1st District of Leyte and also a candidate for the same position, filed a petition for cancellation and disqualification with the Comelec, charging Marcos as she did not comply with the constitutional requirement for residency, as she lacked the 1-year residency requirement for the candidates for the House of Representatives. Issue: whether or not Imelda Marcos was a resident of the 1st District of Leyte to be eligible in running as representative. Ruling: yes, the court is in favor of a conclusion supporting the petitioner's claim of legal residence or domicile in the 1st District of
Hello
Leyte.
everyone, my name is Alfred Guerrero and I'll be going to discuss the case of the Identified GR number 45459, March 13, 1937. The facts are: petitioner agreed by the head of Philippine Independent Church filed a writ of provision against expanded tourism. The director for enjoining the latter from issuing and selling postage stamp commemorative on the 33rd International Eucharistic Congress organized by the Roman Catholic. The petitioner invokes that such issuance and authorized by Act 4052 by the Philippine legislator but the Philippine legislature contemplates future purpose for the benefit of particular church, hence this petition. Issue whether or not the issuing and selling commemorative stamp is constitutional held. The issuing and selling of commemorative stamp by the respondent does not contemplate any favor upon a particular sect, but the purpose was only to advertise the Philippines and attract more tourists. And the government to take advantage of an event considered of international importance does not violate the Constitution on its provision for the separation of the church. In fact, certain general concessions are indiscriminately accorded to religious sect and denomination.
Good morning, everyone. My name is Kashi Polen, and my first case is all about Marcos vs. Romelec, GR number 119976, September 18, 1985. So the fact is, petitioner Enroller Gomez Marcos filed a certificate for candidacy for the position of representative of the First District of Leyte in 1985, providing that her residence in the place was 7 months. On March 23, 1995, Cyril Roy Montero, the incumbent representative of the First District, and also the candidate of the same position, filed a petition for cancelling and disqualification with the Comelec, charging Marcos who did not comply with the constitutional requirement for residency, and actually lacked the one-year residency requirement for the candidates of the House of Representatives. In the direct candidate of the candidacy, the petitioner changed 7 months to since the child under residency. The petitioner's motion for reconsideration was denied. The issue is whether or not Imelda Marcos was a resident of the First District of Leyte to satisfy the one-year residency requirement to be eligible and not as a representative. The ruling is yes. The court is in a favorable conclusion supporting petitioner's claim of legal residence or domicile of the First District of Leyte.
Reporting the case number 187567, Republic versus Sagon on February 15, 2012. Facts of the case. Respondent Sagon was born in Baguio City to a Chinese father and a Filipina mother. She had issued a certificate of live birth that stated her citizenship as a Filipino. Upon reaching the age of maturity, she filed a petition with the local civil registrar of Baguio City to annul her. The local civil registrar of Baguio City denied the petition, stating that Sagon's citizenship was already fixed as Chinese at the time of her birth. Sagon appealed the denial to the regional trial court, which affirmed the local civil registrar's decision. Sagon then appealed the RTC decision to the Supreme Trial Court. Issue whether or not Sagon can elect Filipino citizenship despite of being born to a Chinese mother. Horse rolling, yes. Sagon can elect Filipino citizenship despite of being born to a Chinese mother. The court held that the rule that only legitimate children follow the citizenship of their father does not apply to Sagon because she was born before the effectivity of the Family Code of the Philippines. Under the code, which was in effect at the time of Sagon's birth, legitimate children follow the citizenship of their father unless they had elected Philippine citizenship upon reaching the age of maturity. The court found that Sagon had sufficiently proved that she had elected Filipino citizenship. She had lived in the Philippines all her life, she had been educated in the Philippines, and she had held a Philippine passport since she was 18 years old.
Team Kaupo, and for the first case, I'll be discussing the GR number 180314, People of the Philippines versus Normala Pacaso. The facts of the case, Normala Pacaso, the Regional Secretary of the Department of Tourism in ARFF, was charged of falsification of public documents under Article 171 of the revised Penal Code. She was accused of falsifying the public documents of the Regional Secretary in order to claim her salary of 2 months in advance. However, she appealed, arguing that no evidence of using falsified employee clearance were found. Issue of the case whether or not the petitioner should be convicted by falsifying a public document. As for the rulings, the court had concluded that all the necessary elements for a conviction were present. They stated that as a public officer, Normala was duty bound to prepare and submit such documents, but she took advantage of her own position to accomplish this act. She imitated a signature, fulfilling the criteria laid out in Article 171, paragraph 1 of the revised penal code. So because of this, Normala Pacaso was held by the court as guilty. That's it.
Good day everyone, my name is Arlene Mayojena. My case is year number 127-255 of August 14, 1997. This is Arroyo vs. Competition. Facts RA 8240, which amends certain provisions of National Internal Revenue Code for imposing sales taxes on the manufacture and sale of beer and cigarettes were challenged by Representative Joe Arroyo. The bicameral committee, after submitting its report to the House, the chairman of the committee proceeded to deliver his sponsorship speech and was interpreted. Arroyo also interrupted to adjourn or lack of. His motion was defeated and moved on. The interpretation of the sponsor proceeded and the bill was approved on its third reading. Issue whether or not Arroyo should have been heard for his call to adjourn for lack of vote. Ruling, the petition was dismissed. The court held that it is not the court's role to interfere with legislative actions or allow defeated political actors to seek a judicial remedy. Such matters should be resolved within the legislative department.
Salamat!